Seattle DUI Pros, Nate Webb. I'm just going to discuss with you what negligent driving in the first degree is, as opposed to negligent driving in the second degree. Negligent driving in the first degree is a criminal offense. It's what we call a simple misdemeanor, meaning the maximum penalty is 90 days in jail and or $1,000 fine. It's typically a reduction from DUI in low breath test type cases, or cases where there might not be a breath test for something other than an alleged refusal. The elements of negligent driving in the first degree I've written down here on our webpage, but they are operating a motor vehicle in a manner that is both negligent and endangers or is likely to endanger any person or property while exhibiting the effects of having consumed alcohol or any drug. So it is a case where it doesn't have to involve, quote, impairment or being under the influence. It can involve just having the effects of that alcohol. And so it is a little more subjective to establish the element of that by law enforcement, but it certainly can be established just by making observations that they're trained to make. And so again, it's a common reduction from DUI. And when I say reduction, what it means is that it's a lesser offense. It doesn't hold the same mandatory penalties. No ignition interlock requirement comes with a negligent driving in the first degree, nor is there any SR22 insurance or high-risk insurance requirement for a conviction for negligent driving in the first degree. You could have some personal insurance rates go up, but it wouldn't have any impact as far as jail goes, of course. No jail. There can be a maximum of 90 days in jail, but that would be in a very limited circumstance. It's not normally imposed at all. And so negligent driving in the first degree is a prior offense. If you were originally sentenced or charged with DUI and it was reduced or amended to negligent driving in the first degree, what that means is that under the statute 46615055, that if you're charged with a subsequent DUI from the date of the arrest of the original DUI within a 7-year period, and you are convicted of that subsequent DUI, that the mandatory minimum penalties would significantly increase 30 or 45 days in jail plus electronic home monitoring. That's mandatory as well, even if your original charge was reduced to a negligent driving in the first degree. So I had a lot of people come in and I asked them always, have you ever had any prior offenses for DUI? And the common response is, well, I had a negligent driving, so that doesn't count. Well, yes, it does if it was within 7 years. And so you need to discuss that with your attorney, disclose that with them, because it's very essential in establishing what kind of defense we're going to put up, because it's going to be a much more difficult case if you have a prior offense, even if it's reduced to negligent driving or reckless driving. And so take a look at the page here. It explains everything that comes along with negligent driving in the first degree. If you have any questions, give us a call, 425-398-4323 or 844-DUI-GONE. We're here to help you. We know how to do it. Been doing it for over a decade and helped hundreds upon hundreds upon hundreds of people with DUI offenses here in Washington State.